signify, state your name after she calls your name, and let us know you're here.
Okay, Chairman Dan Moore,
Here. Dan?
Cynthia Lever, Ricky Martin, William McGonigal,
Bill McGonigal here.
Trey Skidmore,
Here.
Andy Thomas, Roger Quinn. Hold on, Mr. Quinn, you were on mute. Roger Quinn.
Yes.
Okay, we have a quorum.
Okay, thank you, Allison. And at this particular time, I'd like to call to order the Zoning Board of Appeals for the City of North Myrtle Beach, May 14th, 2020. Welcome, everyone. And those of you who are presenting the case, we will be as diligent as we can to give you all the time that is necessary and that you need to present your case, and any supporting documents and witnesses. At this time, I'd like to announce that we do have we're a board of 7 members. We have 5 members present this evening for this meeting. We do have a quorum. In the event, since we are a 7-member board in total, we must have, for a variance to be approved, a 4-to-1 vote.
I believe we only have 4 members here.
Wait a minute, myself, Billy, you, Roger, who did I miss? Ricky.
Cynthia and Ricky.
Okay, Cynthia and Ricky, and who else is that?
Andy.
And Andy, 3, okay. So we need a unanimous vote, I'm sorry. Since we're a board of 7, we have a quorum of 4, we need a unanimous vote. Either way. Yay or nay.
What's Andy?
Does everyone understand? Now, we have in the past, we have precedent whereby we have had board members absent, and we have allowed and or done, what we've done is allow members presenting the case to take their case to the next meeting. So everybody understands, in the event for your variance request to move forward, it will take a unanimous vote of the board members present. Any questions? Any questions at all? Okay, there being none, I think we'll just go ahead and open the meeting. And I am here with our city attorney, zoning administrator, and zoning administrator to be. Anyway, we'll discuss that later. All right. We have the minutes of the April 9th meeting, and they were very well done and documented, put together. And I want to commend Allison. Those minutes were very, very verbatim and very well done. Thank you, Allison. Are there any changes to the minutes of the the April 9th meeting? Any additions, deletions, corrections? If not, could I have a motion for their approval? I'd like to have a motion for the approval of the minutes of the April 9th meeting.
Mr. Chairman, this is Billy McGonigal. I didn't, in the packet, on the email packet, I didn't receive it. So I'd like to table that so we'll get an opportunity to review those.
Okay. All right. Let's just go ahead and take that vote.
I'd like to make a motion that we table the minutes, the April 9th minutes to the next meeting.
Okay.
A motion for the tabling of the
Yeah.
April 9th.
Bill,
Yes, sir.
there is one correction at the bottom of page 4, I believe. I couldn't get through to you fast enough here. I'm sorry. It says, note be advised that these minutes represent a summary of the planning commission meeting. What they really meant was the zoning board of appeals meeting.
I saw
Okay.
that.
I just wanted to call that to your attention. It doesn't seem to affect anything else, but it just tell you.
Good eye, Roger. Good
Okay.
eye. All right, we'll go ahead and make that motion. Do we have a second?
Second.
Tabling and the correction. Do we have a second?
I second.
All right, all those in favor, please signify.
Aye.
Aye.
All right, it's 4 ayes. Okay, motion carries. We'll table that and deal with that next, our next meeting. All right, Paul, communications.
Mr. Chairman, we have no communications.
Okay, old business.
There is no old business either.
All right, we'll get right down to new business. All right, at this particular time, those individuals presenting their case, if you would allow the city clerk to swear you in, give you the oath. How do we want to proceed with that, Counselor? What would be the best way? We're going to do it verbally?
It may be easiest, since we're doing this via a Zoom meeting, to have each person who's going to offer testimony be sworn in as the items come up.
As they present.
Yes.
Okay, all right. I think that sounds very judicious. Okay, this is what we'll do. Each of you who are presenting a case, at the time that your case comes up, we will ask you and swear you in at that particular time for your testimony. All right, any questions? All
We
right,
have a board member.
we got a board member who's joined us. Cynthia, welcome. That gives us 5 members. So in order for a motion to approve a variance to go forward, there must be a vote of 4 to 1. 4 to 1. Okay. First item on the agenda tonight is variance V07-20. Mr. Tim Duncan has made an application for a variance to remove a tree in excess of the 24-inch caliper measurement protected by the ordinance at 225 First Avenue North. Mr. Duncan. Mr. Duncan? Is he on mute?
He was here.
Mr. Duncan?
He's not on mute.
Mr. Duncan. Mr. Duncan?
It looks like he's connecting again to audio.
Yes, ma'am. Allison, as soon as we get his audio, I'm going to ask you to swear him in, please, if you will.
Yes, sir.
Yes,
Mr. Duncan, can you,
Mr. Duncan? What number is it?
Mr. Duncan, in the bottom left-hand corner is a microphone. If you see that, you can unmute it. There should be a red line through it, and then if you click on it, and you can unmute it.
Allison, do you have another?
He can call any one of these numbers right here.
Just start with the
The
top.
first one is good, yeah.
First one's good. Mr. Duncan? Mr. Duncan,
He can hear you.
you can?
Yeah.
Are you connected, Mr. Duncan?
Trying to.
Yeah,
Yes.
have him call. Mr. Duncan, can you call? Do you have a phone you can call in with?
Why don't y'all give him the number and we'll see if we can get him to call in.
That's what we're attempting to do, Billy.
He's got a phone number now on there. Let me,
Okay.
Mr. Duncan?
Can you hear me now?
Okay,
Yes, sir.
got you now. All right. We avoided that crisis.
Okay.
Thank you. Okay. Thank you. Mr. Duncan, at this particular time, our city clerk, Miss Allison Galbraith, is going to swear you in for your testimony. If you would raise your right hand, please, for her. Allison?
Mr. Duncan, do you solemnly state, under penalty of perjury, that the evidence that you shall give in this issue shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Thank you, Mr. Duncan.
Okay.
Mr. Duncan, you may proceed with your request.
Yes. Yes. What I am asking for this evening is at location 225 First Avenue North. There is a older home that is essentially a tear down, and in order to build reasonably on the lot, there is a tree that is like a V. I believe it's an oak. I don't know. I believe that Ben might have more information on the tree than I have. And anyway, it is approximately 35 feet off of one property line and approximately 30 to 32 feet off the other property line. So it's located right in the middle of where the building would be when the other older property is torn down. And so what I'm asking for is the ability to remove that and replace it with another type of perimeter tree or something to replace that, to make the lot buildable.
Okay. All right, so you're stating that this particular tree, which I have seen, is going to be in the proposed building footprint envelope, correct?
That is correct.
Okay. Do you have anything else to support that, or anything else you would like to say?
I don't believe so. I think it's,
Okay.
just a matter of where the tree is located.
Okay. All right. This time, we'll get back to you, Mr. Duncan. We're going to hear from the city, and we'll talk. Have Ben. Ben.
All right, petitioner Tim Duncan has submitted an application to remove a tree in excess of 24 caliper inches at 225 First Avenue North. Trees exceeding 24 caliper inches shall only be removed upon approval by the board. The board is charged with setting a suitable tree replacement schedule. City Council has also approved a tree bank where individuals can pay $100 per caliper inch required planting. Staff recommends that the board review the variance application, hear the evidence presented at the meeting, and review section 2368.
Okay. Mr. Duncan, you indicated that Mr. Caldwell had surveyed the tree and he would be able to provide some additional information. Now, he just opened your case. Is there anything that you're looking for him to?
It's a 26-inch tree. That's really all the information I have.
Okay.
How many inches has it been?
26.
How many inches has it been?
26.
26 or 30? I can't hear you. Somebody has music playing.
It's 26.
26. Thank you.
Yes, ma'am.
You know what kind of tree it is?
I do not.
Looks to be an oak tree. Is that correct, Mr. Duncan?
I'm not an expert on trees, to be honest with you, but I believe that it's some type of oak, but I'm not sure what kind of oak it is.
Probably.
And I wasn't sure where you would take the caliper because I thought it was at like chest height and it has like a V. So everything that I've heard sounds accurate.
All right. Thank you, Mr. Duncan. Now we'll deliberate this at this time. Mr. McGonigal, Ms. Lover, Mr. Skidmore. Anyone have questions of the applicant? Questions?
Yeah, Mr. Duncan, went by the property and looked at it. The tree, beautiful tree, but so it is in the footprint of your proposed building. That is correct. And has staff seen that as well?
We haven't.
I didn't
seen
catch.
plans yet for it.
I'm sorry, go ahead, Ben.
We have not yet seen plans for this lot.
Mr. Duncan, do you have anything to add to Mr. McGonigle's question?
Just the only thing that I can say is the setbacks are 10 feet. And that would put it approximately 20 to 25 feet in the center of the developable portion. And so it wouldn't be something that I could work around and design around, because it's just literally right out. I wouldn't say in the middle, but it's 35 feet into a 94-foot wide lot. Does that make sense? So it's about 1/3 of the way across, and we're talking about where the trunk is, and then you have the canopy, and so that renders that entire area. It would just block everything.
And Mr. Duncan, on that note, I'm looking at that, I could see that if you do a sizable house, we just, a lot of people just want to come in and cut down trees, and it's our mission to do the best we can to protect those trees without taking away your ability to develop on that property and put a suitable property. My thing is, I'd like to see a footprint of the house and how it would sit on there, or we could pass it on to staff that it needs to be within the footprint of the house. So Cynthia, your thoughts?
And those are the same thoughts, because if it's a 94-foot wide lot, it's got 10-foot setbacks on each side. It seems like there's still plenty of room to build a substantial house. Because you're losing 94, 10 on each side takes you down to 74. It depends, again, like where the house is going to be situated on the lot.
Can I respond?
Yes, sir, please.
Okay. I'm sorry, I've never done a Zoom before, so I'm an amateur here. So it is not a house that I would be building. It is a resort commercial zoning. So I would be building either townhomes or we have two plans that we're working on. We're working on townhomes, and we're also working on a larger duplex unit.
Gotcha. Okay.
And so it's not a regular, where you would do like a beach house or a Charleston type narrow footprint home.
Do you have any?
Question? Would it be helpful if we did have some kind of a plan just to look at? Since you
That would be helpful, and we can understand, how you want to utilize the property. Mr. Duncan, on the part is, we don't want to stop you from utilizing the property. We want to maximize the property use, but we'd love to see the plan so we can understand how. We have people just want to cut down trees because they don't like trees. So I wish we had a footprint. I'm more than amiable to work with you with the footprint. We just want to make sure that if there's any ability to save the tree, working together, great. If not, we understand that you're developing the townhouses. I think we can work with you. But would you have a problem of waiting the next month and showing us what you're thinking so we could make it a little easier on us?
I think that would be perfect. And then I can kind of show you, I can get both of them from the architect and show you both plans that we're looking at, because with everything so volatile right now, this is investment property. And so we're looking at different, financial returns, et cetera, on the different properties. So would you like me to give you both of them that we're looking at?
Please.
And
Yes.
I could turn those in, and then we could discuss it next month.
That'd be great.
If you could do an overlay of the proposed development on the site with the setback, showing the tree, that would be most helpful.
I'll have Harry Bruton do just a simple site plan over the survey, if that's helpful.
That'd be very helpful.
One
That would be very
thing,
helpful.
thank you. One thing is the home that exists there now is zero setback. It's on the property line against the street right of way.
Right.
So that's why it has quite a bit of room behind the home that's existing, is because it doesn't have the setbacks. That home was built actually on the property line. So I will get a site plan without taking up too much of anyone's time here. I will get a site plan. I will get with Harry Bruton and turn that into Ben, I believe, and then we would have it for next month.
Okay. All right. Billy,
Mr. Duncan,
I'm sorry.
Mr. Duncan, on that note, if you are looking at two options, if you provide us with both options, and if it does, we do realize that the tree is in hindrance of developing the property. I'd like to see both options because we could approve both options and then you would have the ability to do that. If you change your options and it wouldn't affect the tree, then I think that's a different scenario.
Okay, thank you.
Okay, Billy, in light of that, would you make a motion to table Mr. Duncan's request until the next meeting, please?
Yes, sir, Mr. Chairman. Let me see. I'd like to make a motion. We table variance V 07-20 to the next meeting so we can look at some other information.
Supporting information, okay. All right, we have a motion for the tabling of this particular item subject to additional information.
I'll second it.
All right, Roger, second. All those in favor, please signify either with your name.
Cynthia Lover, aye.
Billy McGonigal, aye.
Roger Quinn, aye.
Right?
Russ Skidmore, aye.
All right. Aye. So it's unanimous. We'll table that to the next meeting. It's second Thursday in June. All right. Next item on the agenda tonight is appeal D3-20. Mr. Mike Todd has filed an appeal of the decision of the zoning administrator that an RV recreational vehicle parked in the front yard at 502 35th Avenue South is not grandfathered and thus allowed to remain parked there. Now, I see that Mr. Todd is represented by counsel this evening. Mr. Truslow, counselor, could you allow the city clerk to swear you in, please? Allison?
Mr. Truesdale, do you solemnly state under penalty of perjury that the evidence that you shall give in this issue shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay. Thank you. Thank you, Mr. Truesdale.
I was going to ask that this be tabled, and I know I've been in this for 30 minutes now here, but a couple of reasons. One, I know how to do this Zoom. My client does not. I wanted him to be with me. I wanted to put a presentation person. I've got a couple of photographs. I'm able to get on Zoom and do it, but I'm not sure how to show you the photographs during this. I just feel like now, a month out, we may still be doing Zoom meetings. I don't know. But there may be a chance that we're back in regular meetings at that point, but that's where I am with it.
Mr. Truslow, you're stating that on behalf of your client, you would be more comfortable at an in-person meeting whenever that occurs.
His caretaker also is watching it, but she is with her elderly mother out of town. She is also the person who transports him around. So he's not in my office or where I am at home to get on with me. There was no way to get him there outside of me transporting him, and with it's not really something I'm going to do.
Okay, and I would imagine something like that's not recommended for him to be exposed anyway.
And I was thinking for me either, but
That's correct. I mean, this is new for everybody. So we want to give every applicant every opportunity to present all the information they possibly can gather.
Yeah, and I just don't want it to be curtailed by a different process. I mean, it's a pretty important matter to him, and it's, I don't know, to me, it's unique, but you guys probably see this stuff all the time, but some of the issues with him and how long it's been, and I certainly want him to be a part of it.
I certainly understand that.
Mr. Chairman,
Chairman Moore, for the record,
Yes.
the city would oppose the continuation of this item. This has been before the BZA and continued numerous times in the past. Mr. Treslow has been aware of the Zoom meeting for this particular item for some time. Could have made arrangement with his client, have his client present via Zoom. Mr. Treslow has sent me some photographs, aerial photographs, and some information that you emailed to me, Kirk, in reference to the vehicle that's in question here. We have all of that information that you emailed to me. I can put it up on the screen and show it to the board along with yourself and whoever else might be watching. If those are the photos.
You can pick up Mr. Todd for me, Chris, and bring him over.
Well, what about this? Kirk, if you can contact Mr. Todd while we do the other applicants' items.
What do you want me to contact him about? You want me to give him a ride here? And that point's undisputed. He can't get on this Zoom meeting right now. But if we're going to go forward, I'll go forward without him.
If you're able to get it by phone.
Can I speak, please?
Excuse me, ma'am, and have him join the meeting via Zoom today.
Are you going to bring him a computer?
No, I'm not.
Okay, well, that's a problem then. But look, I'm not trying to be, I'm having deja vu, from city court years ago with you. I don't want to be litigious about it. I'm just set forth what I said. If I have to go forward today, I will. And I would appreciate if you can put those photos and all in for me, then maybe that works. But, it's a pretty important thing to him, and I'll have to go through and regurgitate the whole meeting and everything that was said and done. But that's not your problem that he's in the position he's in. So, but I'm just asking. So there's nothing more I can say about that.
Well, at the end of the day, the decision is for the board to make, but the city attorney on behalf of the city would object to the continuation of this matter because it's been before the board on several different occasions in the past.
Well, I'd like to be clear on that, how many times it's been.
Well, if I can just finish.
I've been several times.
The city has been prepared, is prepared to go forward today, and I believe Mr. Truslow is prepared to go forward. I spoke to him about this several days ago, and he indicated to me that he was prepared, would attend the meeting, and so on and so forth. So I had a reason to believe that he would be ready to go today to present this case.
Well, I just want to be clear on, I'm unaware it was before the board several times, Chris.
Mr. Treslow, it was on our last month's agenda, and I believe on the month before.
This is at least the third time.
Yeah.
Well, let's do it.
You requested a continuance the first time it was on here because you said you had a court conflict.
Okay.
I did.
So, I mean, that was 3 months ago, and then we tabled it last month.
Yeah.
Mr. Treslow,
Mhm.
on behalf of the Zoning Board of Appeals and your client, you stated earlier that you are prepared to go forward.
Yeah, I'm ready. Yes, sir.
Well, I would, on behalf of this ZBA, really encourage you to do that.
Yes, sir. I'm ready.
Okay, if you're prepared, then we're prepared. So you've been sworn in?
Yes. I don't think I was yet. Was it? Yes, I was. Yep.
If you were.
Before we begin, there was, Ms. McCaskill was asking to be heard. We probably should ask her to weigh in. And Kirk, I don't know if you can weigh in on whether Ms. McCaskill will be testifying or not.
No, I mean, I'm not calling her for any purpose, no.
Okay. Ms. McCaskill, if you can hear, you're simply in observance as a member of the public. Is that accurate?
Yes.
You have anything to state, Ms. McCaskill?
Not right this minute. And he is not able to, it's just what Mr. Truslow said, so.
Okay. Just want to give you the opportunity if you had anything to say.
And
This particular time, then, without further ado, Mr. Truslow, I would like to ask you to to go forward.
Yes, sir. Thank you. And I'll be brief with this. It kind of merges into the next issue on there as well. And obviously it's two separate issues, but
We take one at a time.
let me just point out and say that I truly hope that I'm not coming across as difficult. I really don't mean to do that. I want to do the best job I can for Mr. Todd, and I believe in his cause here. I was simply just trying to do it the best way that I knew how, and set that forth in front of you all. And I was encouraged to go forward, and I agree with that. And I am prepared to go forward, as I told Mr. Nuri a day ago. When it comes down to it, there was two issues that I had. This has to do obviously with Mr. Todd's home on 35th Avenue South in the city of North Myrtle Beach. He has a large motor home, and currently, and for the past in excess of 33 years, it has been located parked in front of his house, to the side of his house, but in front of the house, not behind. Initially on my paperwork, I put in a grandfathering argument, which, as well as a vested right, which actually I think are kind of two different things, but nonetheless, Mr. Nuri has shown me recently an ordinance that goes back prior to the ordinance involved in this case, where it was apparently in effect prior to 1988. So I had an issue that he was using it lawfully, his property, and that prior to the 1988 ordinance. Now, in terms of that being authenticated, it was presented to me, and I got a photocopy of a ordinance zoning booklet, and it's got 1977 on it. So if that is accurate, that definitely weighs in on that argument, and I would move on to the variance issue. Okay. Although, for the record, I would like to say on that issue, whether he's grandfathered in or not, when it comes to that issue, there's something called, I think, a vested right in how you use your property. Along those same lines, he's had that property, the motorhome on that property for 33 years. That's quite a long time for it to be overlooked or not brought up. To say he's become accustomed to that and really set everything in his life around where it's kept. It's a significant financial investment. When he purchased it, had no knowledge he couldn't keep it there when he did, and he's had it for 33 years in the same spot. So he has openly and actively used that property in that way. The ordinances were amended, or actually maybe pulled together and organized in 1988 and published, which are the ones that we look at now. And it says, relevant to our case, that the motorhome has to be behind the building closest to the road in front of it. So in other words, he would need to have it behind the line of the front of his house, on the side of the house. Going into the variance issue.
If I could stop you at that point, we're gonna need to take these things in order. And the first thing that we have in order on the agenda is the grandfathering issue.
That's what I'm talking about.
Well, what I wanted to kind of clarify on that issue, are you abandoning your position that his motorhome is grandfathered?
No, I think that the city will have to show the board that and authenticate the document that you say was in existence back in the 1970s. Okay. Certainly we have no knowledge whatsoever. All we know is that we have the ordinance we're dealing with that he was ticketed under, and that's in effect now. And it is an ordinance that was enacted in 1988, and it has no reference to any prior ordinance.
Got it. Now,
we do.
On the grandfathering issue, do you have any other evidence you wish to present on that issue?
That's what I was talking about at the time. I mean, it's pretty simple, actually. Prior to 1988, he was lawfully using his property. He was in compliance. The ordinance on the books now is dated 1988. So at that point, he would have had his motorhome in that position for a number of years already. Okay. And then it became that he could not. He went another, 22 years, even after the 1988 ordinance, keeping his motorhome in the exact same spot. So yeah, I mean, so that's the argument that he, and there's also in the ordinance, in the same area as that ordinance, that if you're in lawful use at the time that it's changed, that you can continue in lawful use. If you do anything different, you need to update or get in compliance. So we're arguing on the lawful use, prior lawful use of the ordinance, and that he should be permitted to continue the identical use based upon that, and based upon the ordinance itself that speaks to lawful use prior to the ordinance. So that's what we were saying about that.
In your petition that you prepared on behalf of Mr. Todd, you indicated that he's had the RV on the property for 33 years.
Yeah.
Okay, so 33 years from 2020 is 1987?
Yeah, it could be 86, but yeah, right.
Okay, so 86 or 87, he had the RV on the property since that time going forward. All right, and he did not have the RV on the property prior to 87 or 86.
As far as I know, he did not. I think it was purchased at the time he began to keep it at his home.
That's an old Airstream.
Sir? Yeah, for the Airstream.
Okay, so it's your testimony that the RV was there from 86 or 87, but not prior to that.
No, it's my testimony that it was there from 86 or 87 to the present time.
Okay, and that was the question that I asked.
Yeah.
Okay, thank you for confirming that.
So I don't want to take more time on that issue. That's it. The decision to be made on that one. To address quickly the variance issue.
Well, we're gonna, Kirk, we're gonna have to come to the variance issue separately from the.
Okay, well, that's all I have on that issue.
Okay, at this point, the city will present its information on whether the vehicle was
The
grandfathered.
photos we mentioned have to do with the next variance issue, not this one, so that's fine.
And if I can get the document pulled up,
Which one?
this is the, I think you had it in Google Chrome.
Oh, this is one of the long thing. Yeah, okay.
What are we doing at the moment?
We are going to pull up some information. We thought we had it readily available. Someone else had come in and used the computer, so we're pulling the stuff up.
Okay, so I'd like to ask Mr. Treslow a question.
Yes, ma'am.
Okay, I'm reviewing the case of Phil Hallaker versus the Zoning Board of Appeals for the City of Beaufort.
Okay, that's not it.
And it states that that you're saying this motor home is a use of the property. And I believe under that statute, that's incorrect reference because there's a difference between an activity and a use. The use of the property is for a residence, and the particular activity,
Yes.
having that activity is not a use. Keeping a motorhome on a property is not a use. The use is a residence. The activity is keeping the motorhome there. So I'm sort of splitting hairs with you over your word.
Sure, I know, I agree with that, and I think I speak to when I talked about the vested right or use of it. So I think it would go into the prohibited conduct of where it's parked under the ordinance and being grandfathered under that, based on acting in compliance prior to the ordinance, and then after the ordinance, he's not, but he was in compliance prior to, right? So, yeah, I don't need to use the word use. I'm saying that he was engaged in the lawful parking on his property of that vehicle. And then the law was changed during his, during the time he was parking it there. So
How did you establish the law was changed since 1987?
The dates on the ordinances, apparently that was the date they were codified.
I thought the date the ordinance went into effect was 1977.
Well, no, the ones currently that I can look at and everybody else can look at in the public is dated, the amended ordinance is 1988. Now, Mr. Nuri told me that there were, Mr. Blush told me he thought that they had ordinances or the rules were the same back in that time. And so apparently there were ordinances prior to this I didn't know about that were given to me recently. So my only point earlier was I think this has probably become more of a variance argument in the next issue. However, I just said I think that needs to be authenticated because there's no public, there's nowhere in the public eye that you can find what was the ordinances back in that time prior to 1988. That's what
Prepared to do that.
it in under the 1988 ordinance, obviously.
Ms. Lover, we're prepared to do that regarding the documents going back to 1977.
Okay.
Okay, and if you could pull the document back up. Okay, and if you'll scroll down that portion of it right there. All right, Mr. Blush, do you recognize the information that's in front of you on the screen?
Yes,
Okay, and how do you recognize that?
well, it's in the zoning ordinance and we've been enforcing it. I'm not sure what you mean by how do I recognize it.
Okay, so, well, let me ask you this, have you read it for me to yourself, if you would. And just let me know when you're done reading.
Yeah, okay.
All right, do you recognize that language from any of your workings with the city in the past?
Yes,
Okay, and do you recognize this to be a code section of the city of North Fort Worth?
yes.
All right, and if you'll scroll back to the top, well, I'm sorry, go back down to that section. What's the section number of this code section?
Okay, 23-113,
All right, what's the title?
parking, storage, or use of major recreational equipment.
And what does this regulation, what does it do? What does it require? You just explain what it is.
Yeah, essentially, it defines major recreational equipment and tells you where you can park it on the property. And it has to be behind the front line of the house.
And there's a note in parentheses at the bottom of the document. Can you explain what that is?
It's the ordinance number and a date of the adoption of the code that it's in.
So that this particular code section was adopted when?
November 1st, 1988.
Okay. Now, if you'll scroll back up just to the top of this where it says Exhibit 1, right, keep going there. And Mr. Post, if you would read the title of that document.
Read what's
Where it says very in bold at the top, it's underlined.
certificate of record.
Yes.
Okay. Certificate of record.
All right, and then if you'll read what the.
Is that what Allison is?
Just read it out loud if you would.
I, Allison Galbraith, city clerk for the city of North Myrtle Beach, hereby certify that the attached documents are maintained by the city of North Myrtle Beach. And these records are true, accurate, and complete as kept in the normal course of business.
And just for the record, the city will move that this item be admitted into the record regarding this hearing. And I'll need the board to act on that.
Okay. All right, ladies and gentlemen, the city attorney has asked for us to verify and certify that this particular certification of record,
Well, actually to allow it into the record.
okay, to allow it into our record for this particular request.
And Mr. Trussell, do you have any objection?
No, I don't. No.
All right, I need a motion, please, to enter this into the record.
I'll make a motion that we enter section, which I cannot see the number on, the code section that's on the screen into the record as a city's exhibit.
We have a motion.
And if we could get, there was a motion, I think we need someone to second and then.
We need a second, please.
I, Billy McGonigal,
Now I
second
can
that.
say, I make a motion that we enter section 23-113 into the record as an exhibit from the city.
All right,
Yeah.
Billy. We have a motion. Do I have a second?
I, Billy McGonigal, second that.
Thank you, Billy. Any further discussion? There being none, all those in favor, please signify.
Aye.
Aye, Cynthia.
I, Billy McGonigal.
Roger Quinn, aye.
Aye, Dan Moore. Anyone else? Good.
Did we get everyone to vote on that, all the board members?
Got five?
Okay, we're going to continue on, and if you can scroll down.
Motion carries.
All right, we need to get to, the exhibit number 2. You may want to scroll back up. Exhibit 2. Okay, now from there, scroll back down. Keep going, keep going. Okay, right there. All right, now, Mr. Blush, would you please, first of all, do you recognize this document?
Yes,
And again, what is this document as it relates to section 23?
this is an ordinance that describes major recreational equipment and where you're allowed to put it on your property, essentially behind the front line of the house.
So is it the same language as the document we just saw?
Yes.
Okay, when was this adopted?
As far as I know, it was 5/3/1977, May the 3rd, 77.
So from from the current time to 1988, we have the same ordinance in place regulating the parking of the homes and sidewalks. Is that correct?
Yes,
Yes. Okay, at this time, the city would move that this document be entered into the record. Well, let me back a little bit. If you could back up to the certification. There, and this is the certification regarding the document we just saw. And Mr. Blush, if you could just read what that is.
Okay, certification of record. I, Allison Galbraith, City Clerk of the City of North Myrtle Beach, hereby certify that the attached documents are maintained by the City of North Myrtle Beach Clerk, and these records are true, accurate, and complete as kept in the normal course of business.
Okay, so we move that this item be moved into the record and would ask that the board accept that.
Okay, I'll call for a motion to accept Exhibit 2. The item just read by the zoning administrator be adopted into the record. I need a motion. Please.
So moved.
Mr. Quinn,
Yes, so moved. I move that the document be entered into the record.
okay, we have a motion. Do we have a second?
Ray Skidmore, second.
Race, Skidmore second. Any further discussion? All those in favor, please signify.
Aye.
Cynthia?
Aye.
Roger?
Billy,
Aye, Ray. Billy?
Billy McGonigal, aye.
Aye, Dan Moore. We have unanimous.
And Mr. Chairman, is in the record at this point?
It is.
Okay, thank you. All right, one more of these painful documents to go through, and if you could scroll up to, okay. Scroll up.
We're starting to get good at this.
Okay, on this page right here, Mr. Blush, do you recognize what that is? And if you could scroll up just a little bit further to show the year at the bottom of this page. All right, Mr. Bluss, can you just explain what that is?
Well, that's the front of an old zoning ordinance from 1977.
Okay, so that's the front of the zoning document that was in effect in 1977.
Yes.
All right, and if you'll scroll down a little bit further to where you see section 106. Okay, section 106 there, it was that regulation in effect in 1977. Mr. Bloss.
Dates at the bottom, isn't it? Probably.
I have to assume that it was. I've seen this before, and I wasn't with the city in 1977, but I've seen this before, and in my estimation, the answer would be yes.
All right, when you came on board, what year was that?
1984.
All right, and in 1984, was adopted in 1977 and effect at that time?
Yes.
Okay, so this is from the zoning code of 1977.
Yeah, it looks like it, yes.
Okay, so it would be in effect.
Yes.
Okay. And what does this, the code section that you're looking at, what does it do? What does it regulate?
It regulates major recreational equipment and where you can park it on residential property.
Is it the same language as the other two documents that you just reviewed that cover the history from 77 to today's date?
I don't know if it's exactly the same without side by side, but it looks like it's the same.
Okay, and they regulate where the recreational vehicle can be.
That's correct. That's correct.
And where in 1977 does it state that recreational vehicle, where it can be placed within
Behind the front line of a house
is that the
or in a
same,
carport or enclosed building. I didn't say that before, but that's the same language.
is that the same language is enforced in 1988 in current date?
Yes.
And if you'll go back to the certification. And again, if you can just go through the certification process, Mr. Bush, is that, if you'll just read the certification.
Certification of record, I, Allison Galbraith, city clerk for the city of North Myrtle Beach, hereby certify that the attached documents are maintained by the city of North Myrtle Beach city clerk, and these records are true, accurate, and complete as kept in the normal course of business.
Okay, at this time, the city will move that this item be admitted into the record.
Okay, ladies and gentlemen, one more time, this is city's exhibit number 3 in regard to this particular case, certification of record. Do we have a motion for the acceptance into the record of this exhibit 3?
I'll Ray Skidmore motion to accept exhibit 3 into the record.
Thank you, sir. We have a motion for entering this into the record, exhibit 3. Do we have a second?
I'll second it.
Second for Cynthia.
Cynthia Lover, second it.
Thank you. All those in favor, please signify.
Aye.
Aye.
Aye, Billy McGonigal.
Aye.
I, Roger Quinn.
Okay, Roger, we have a unanimous acceptance of this into the record, exhibit 3.
Well, it's the city's position regarding the grandfathering that Mr. Tressler has put forward, that his client would enjoy grandfather
If
benefit.
you're wrapping up, I'd like to ask him a question real quick. You question,
Sure.
Mr. Bluss.
Yes.
So there's 3 documents you put up, one from 1988, one, and then the last 2, one was 1977, and then it was 23-80, and then there was a 1006, this one, last document, correct?
Yes.
What, all right, so 2380 was 1977, right? What was, what's the date, the 1006 right here? Is that prior to the 2380 document ordinance?
I don't know for sure, but I think what happened was in 1985 or so, we weren't using the municipal code corporation. And that 1006 number was the number that was adopted in 1977 or even before then.
Okay.
And when we went to municipal code, they gave us new section numbers.
Okay, I got you.
It became section 23.
All right, thank you. I just have one other last question. You see the yellow cover of the book right there, 1977, and that's kept in the ordinary course of business. Where did you find that?
I didn't find that. Chris Norrie got it from somewhere.
You know where that came from?
Yes, that came from the clerk's records. Don Snyder got that out of the planning department's records, out of the planning department's library and archives, and it's part of the city's records.
Okay. All right, thank you. That's all I wanted to know.
Well, it's the city's position that the regulation of recreational vehicles being parked in the yard has been regulated since 1997. Since 1977, it's been regulated from that time frame going forward in the 2020 without any kind of break in that regulation as established by the city's records. Mr. Truslow has indicated that his client had the vehicle approximately 10 years after the regulation was adopted in 1977, which regulated where these can be placed in the yard. Therefore, his argument that his client should get the benefit of a grandfather clause is defeated because the regulation was in place prior to his placement of the vehicle in the yard. Okay. But the board will have to make a finding on that issue.
Okay. All right. Thank you, Mr. Dewar. Mr. Truslow, do you have any rebuttal to this?
No, sir.
Okay. All right. Questions from board members? Considerations and questions?
None.
Hello.
I just got a general question.
Okay.
The motorhome is the same. He's had the same one for 30 plus years.
Yes, sir.
Okay.
It looks like it. It's old timer.
Looks like a bullet. Like
Yeah.
Airstreams.
Airstream, old Airstream mobile. Questions? Board members, weigh in, please. Questions of Mr. Truslow or the city?
I'll tell you what, just to make it simple, I mean, after he's authenticated these documents here, and I may have left that first argument out of this had I had possession or knowledge or been able to find this document. So I'm going to withdraw this issue, and you know, when it's my turn again on the separate variance issue, I would like to address that at that time. So you don't really need to vote on this one or anything. I would withdraw the argument as to the grandfathered in and move on to the variance when that time comes.
I don't know. I need guidance on that.
Well, if the applicant is withdrawing his
Request.
petition or request that this is grandfathered, then I think the board should vote on the applicant's request that be withdrawn and enact on the withdrawal or the request for withdrawal and remove it from consideration.
Okay. Board members, you hear that?
Can you clarify that for me again, please, procedurally?
Ms. Lover, the petitioner's attorney just indicated that he wants to
Correct. Withdraw it.
withdraw this item from the board's consideration. And my advice would be that since he's made a motion of effect to withdraw this, that the board vote on the withdrawal and act on it and formally withdraw it from the agenda.
If he does that, then can he come back with it again next month if he changes his mind? If we say, okay, you can withdraw it instead of ruling on it, does that mean?
That's actually a good point. And following up on that, since we've gone through the issue of covering all the bases, the board might as well act on whether he's grandfathered on this or not, as opposed to allowing the withdrawal.
Instead of withdrawal.
instead of the withdrawal, but since he's presented his testimony, the city's presented its information, it would be appropriate for the board to simply act on the grandfather motion.
Probably since it has been advertised, that we should.
I'm not making this longer. I was trying to make it shorter for you.
Right.
I understand.
All right, my fellow board members, if you have questions or any other considerations or anything at this time, please, or otherwise, I need a motion on this particular request.
And it would be either a motion to deny or approve of the grandfathering issue.
I would like to make two motions on the grandfathering issue. So
Okay.
Go
the
ahead.
first one, I would like to make a motion. By the way, this is Cynthia Lover for the record. I'd like to make a motion to deny the appeal of variance D03-20, the appeals portion of it, on the grounds that as a factual matter, the city has established that code section 23-80, which may have also been known as code section 1006, was in effect prior to 1987. Therefore, as a matter of fact, the use of the vehicle on the property could not be grandfathered in.
Okay.
Mr. Chairman, this is Billy McGonigal. I'd like to second that motion.
Okay, we have a motion and we have a second. Do we have any further discussion? If not, all those in favor of the motion, please signify by stating your name.
Aye, Billy McGonigal.
Thank you.
Aye, Roger Quinn.
Thank you.
I, Cynthia Lover.
Thank you. Ray?
I, Ray Skidmore.
Aye, Dan Moore. It's unanimous. Motion carries. This is,
Now, before we get into the,
I would like to make one more motion if I can,
absolutely.
please. And this is maybe overkill, but procedurally, I would make a motion that we deny the appeal and variance D03-20, ground one, on the ground that the appeal before us references the motorhome on the property of the petitioner being a use. And I think this is a misstatement, and that the motorhome on the property is actually an activity. And therefore, I would make a motion that we deny the appeal on the grounds that the document before us, the appeal and variance document itself, is incorrectly labels the activity, the underlying cause of action by the petitioner.
Would you
That as
say,
a matter of fact, the vehicle on the property is an activity. The vehicle on the property is not a use.
everyone clear? Any questions?
I have a question. Are you talking about the variance issue or this issue?
I'm still talking about the grandfathering.
Yes, okay.
The grounds as it's referenced in the appeal from the municipal ordinance summons that was submitted on January 22nd, 2020 by Mr. Treslow, references storing the vehicle on the property as a use, saying that we're denying a lawful use. In storing the vehicle on the property, to me, is not a use of the property, it's an activity on the property. Therefore, I think just as a matter of fact, my motion is that, as a matter of fact, it's mischaracterized. The vehicle on the property is mischaracterized, and on that grounds, the appeal should also be denied.
Oh, okay, thank you. Do the ordinances deal with the activity or just the use of property?
Well, we can go back and read it.
Okay.
If we could put it back on the screen.
Go back to the one that's in effect currently, and scroll to the top. scroll to the top of that document, just close out.
No, I just closed it.
Yeah. And just scroll to the top of it, yeah. Keep going.
2380.
Keep going up a little further, down a little further, right there.
Okay, well, I'll withdraw that because the last sentence does say, or any location not approved for such use, instead of saying any location approved, not approved for such activity.
So you're gonna withdraw your motion?
I'll withdraw that second motion.
Okay,
Okay, now before we move on to the variance, in Mr. Truslow's petition on behalf of Mr. Todd, he has language in here in reference to vested rights. Mr. Truslow, do you want to present anything on that issue, or do you feel like you've already covered that?
Yes,
You feel like you've already covered?
I've already covered it.
Okay, the city's position on vested rights is that that is not applicable, and it's not something that this board would consider. Vested rights is a legal theory regarding zoning law, and it would be applicable in a situation where a petitioner is claiming that they have the right to use a certain zoning designation, such as highway commercial or R1, and that they have a vested right to continue in that use. In this situation, that issue is not before this board. We're not trying to change the use of his land and zoning it to another use, such as R1 to highway commercial. That's not happening. So Mr. Truslow's position that he wants the board to consider vested rights, that's simply not an applicable legal theory that this board would consider, because we're not trying to change any vested rights that he may have to use his property, which is zoned as R1, to some other use.
so this board you're stating is not in a position to vote on this.
That is correct, that it's not an applicable legal theory to
So
what was
that-
presented.
So that nullifies the variance request.
It does not nullify the variance request. The vested rights argument that Mr. Truslow has put forth is a legal theory in zoning law, but it's not applicable to this situation. It would be applicable if I can just give you a quick example. Let's say you own a piece of property on Highway 17, and you pulled a business permit or a building permit to build something on that piece of land and use it for highway commercial. Then the city advertised to change that to R1. You could then argue to the court that you had a vested right to continue in that highway commercial usage because you got a building permit to use it for highway commercial. That's not the situation that's happening here, where the city is not attempting to change the zoning on Mr. Todd's land. So a vested rights argument to continue in that use would not be applicable, therefore wouldn't be something that this board would consider.
So proceeding forward on the variance request.
Well, I think we gotta close the loop on the vested rights matter. And the city would move that the board find that the vested rights issue is not an applicable legal theory that this board is going to weigh in. Not that it's moot, it's just not an applicable theory that this board is gonna weigh in on.
Is everyone clear of any questions in regards to this matter, in particular, the variance request?
And this is not the variance request. This is, again, Mr. Truslow has asked in his petition for a finding regarding vested rights. He's put forth his arguments, and I've offered an explanation that vested rights is not applicable to this situation. And the city would move that the board find that it's the vested rights argument is not applicable for the board's consideration.
Okay. Everyone have a grasp of this? Okay, I need a motion in regards to variance B09-20.
But before we get to that, if I could, Ms. Lover, I don't know if you can hear me or not, but if I could possibly get a motion regarding the inapplicability of the vested rights position or argument on behalf of Mr. Todd to this matter, and that the board's not going to consider vested rights because it wouldn't be appropriate for the board to consider that.
I understand what you're asking, Mr. Nuring. I was going to say, I don't have any authority. Is there legal authority one way or the other? Because that's not really in front of us to make.
It is in front of you via the petition. He submitted this petition, that's in there, and I didn't want to not have the board address that.
Chris, I sent you a document that I put together as a petition, and Mr. Blust told me I had to fill out a form. There already was, and I did that. And that form is more the variance issue. The document I created that was my petition that I filed brings up what you're talking about, which I agree is not an issue anymore. Maybe they're saying what they're looking at.
Board members, if you can look in your package that you the petition that Mr. Trussell submitted is in that in the package that you have in front of you. And it's, you know, captioned, the state of South Carolina, County of Moree, William McDodd, petitioner, Elton Farmer Jr. respondent, appeal for municipal ordinance summons. Do you see that document in your package?
I do.
Yes.
And if you'll turn to the second page of that document, in paragraph 2, he has his vested rights position in there.
Yeah, I saw that.
And since this is an appellate matter, and there's a very good chance that Mr. Trussell is going to appeal this, I think this needs to be addressed by the board and not simply overlooked. So the court will know that the board acted on it one way or the other when it's reviewing the record.
Why do you say there's a very good chance I'm going to appeal that, Chris?
You said in your email that you were going to.
No, I'm asking for a variance in the next thing. I mean, is it over?
You prepared this petition.
Wait and argue for that next.
But I can finish. You prepared the petition that you wanted this board to consider vested rights. Did you not? It's right here.
Oh, sure. I'm just saying I don't need to appeal yet, do I?
No, but you've indicated that you were going to. So my advice to the board is that they consider everything in your petition and act on it.
Okay. I'm not.
Because there's a good chance that this may go to a court of appeals in the event that you do appeal this. And if you do appeal it, the appellate court is going to have to look at the actions that this board took regarding the items in your appeal.
Right.
Petition of it.
I think you're right. I think you're doing a fine job, and pointing out that.
Well, thank you.
All right. Well, I can make a motion, but if you would like me to make a motion.
Yeah, please go ahead.
All right. I would make a motion that presented on based on the evidence presented by the city attorney that vested rights is that the term vested right is not applicable to a variance request. Instead, it is a term of art to be applied to a change of zoning and not a change of activity on a land, that therefore we deny we deny the appeal on the second ground of petitioner's appeal.
Okay, we need a second.
Ray Skidmore, second.
Let's get more second. Any further discussion in regards to this? Any further discussion? There being none, let's call for the vote.
Aye, Billy McGonigal.
Bill McDonald, thank you.
Aye, Roger Quinn.
Thank you, Roger.
Ray Skidmore.
Great. Dan Moore.
Aye, Cynthia Lover.
Cynthia Lover, it's unanimous. The request has been denied.
Okay, now, I guess the next item on the agenda, not I guess, the next item on the agenda is the variance, and we're ready to go into the variance.
Okay.
I'm sorry, Chris, what? Various issues now? Is
No,
that what you said?
going on to the next item on the agenda, which is your petition for a variance on behalf of Mr. Todd.
Yes. You're ready for me to present that
Mr. Chairman,
or
I'll
not?
We are at this time. Yes, sir.
All right. Briefly, in case anybody missed it, Mr. Todd, elderly gentleman, poor health, owns this motor home. It's probably an antique by now, but he still works on it, hopes to get it on the road. He's used it in art shows and his artwork, transporting items, making a living. He purchased this back in the mid 80s. He lives on 35th Avenue South in his home. He parked it and has always parked it for 33 plus years in front of his home towards the left side of the home. Mr. Nuri, if you would please show those two pictures that you said you would show for me.
Yes, we will do that. And if Roxanne, if you can pull that information up.
And I'll comment something on the pictures and then that'll be about it. We're asking the board to consider giving him a variance to allow him to continue to have this Airstream parked where it is on 35th Avenue. Not many people even see this Airstream parked at his home, and truly it's not an eyesore. He also lives on one of the avenues doesn't even go all the way down to the boulevard. I mean, not many people even drive on it. It's got the parallel road that goes through it, so it's about half of most avenues, and even up to the top actually doesn't go all the way. So it's a small block there. He's had it there for 33 years. Actually, he's had it there so long that the only place he could have had it to have it behind the house has grown trees that are now trees that he would have to actually cut down some big trees to reclaim the side of his house. He has no other place to put this Airstream, and no one's had a problem with it for 3 decades plus. The other side of his house, there's no room. There wouldn't be no way, based on how his property is, that he could even get it to the backyard. The next photos will show you, if you move to that second photo, please.
Is that it?
It is a shot of the front of his house.
These are the photos that you sent, Kurt.
So what you can see, and I'm going to try to still show this to Chris, get it to him, but you look at the front of his house and you would see the front door, front of a house. On the left side where the Airstream is, it's parked there. It's not on the road. It's probably back about 6 or 7 feet from the road. And then behind it, you'll see the side of his house. There are trees, full-grown trees. It could not go behind his house. Now, part of why it's like, and the other side, there's no room as well. So he could not really comply with this outside of really doing some serious work to the lot. Those trees, actually, when he was openly parking this there for 33 years, they have grown during this time. I mean, I'm not saying that people have to go out and tell everybody what the law is, but I mean, for 33 years, nobody has a problem with it. And you parked it there and you don't think about it. And now they tell you to park it and move it back. And after 33 years, you have these huge trees that have grown in. So, and I don't think Mr. Nuri will disagree with me. If so, I'll get this picture there one way or another. Now, there's no room for it on either side of the house, which the ordinance obviously says it should be behind the front of the building closest to the road. He has it far as back from the road as he can. It is not an obstacle to the road. It's not close to the road. There are hardly anybody that would see it, except for neighbors that live around that road. As far as he knows, nobody's ever given him a hard time about it. This was a significant financial investment, and it was, not the city, I don't guess, but it's been acquiesced in for 33 years. We're simply asking the board to consider all the facts. And he's on a fixed income and probably could not afford to go lease a lot, put it on, or a storage unit. He's lived there, a lifelong resident, and he's always had it there. We're just asking the board to consider allowing him in his elderly years to keep the Airstream that he's had so long where it is. Where he's always had it at his home. And I would like to find a way here quickly to get this email right to Chris. I thought I sent that one, but I'd like you to see the picture pointing at his.
First, for the record, the documents that you emailed to me were the aerial photographs, and I think there were 3 or 5, and we can go through all the aerial
Well, how
photographs.
many? Okay.
And then you sent another. I just want to add one comment. You sent another document that had some printed information regarding the Airstream itself, but you did not send any photograph regarding the front of its home.
Okay, well, I just sent it to you. Can you put it up somehow for us? I just now sent it to you. And again, it's a Google Earth shot like this, but way closer down on the home. And you can see how far back the Airstream is from the road. You can see the home, the Airstream there, and the trees, mature trees that are grown on the side of his home, which leaves no room. Or otherwise we wouldn't be here. He would have backed it up into there. But there's no room on the way his lot is and his home is built, the way it's been for decades.
Roxanne, are we able to get the Google Earth shot up?
If you want to find it on Google Earth.
So basically, I'll wrap it up. I mean, he has asked me to come before y'all to request this, and he respectfully asked for it. I truly don't think it hurts anyone, and that's why we're asking. I guess our only recourse is to ask a variance, allowing him to continue to keep it where it is. So hopefully, I'm going to finish now. I am finished, and hopefully Mr. Nuri can pull that picture up. It's just one last picture.
That's the address right there. We're trying to get it pulled up.
Yes, thank you. So that's really all I have, unless there are questions. I did mention his age and health, and he's on a fixed income, and the amount of time that's gone by. So if there are any questions, I will be happy to answer them for him.
And Kirk, you wanted to do a street view of the front of the house, is that accurate?
Well, it's actually kind of on top of the house, but it shows both sides of the home, front yard, the Airstream, and the home and the road.
Yeah, I think that's 36.
It confirms.
It's close.
It's the wrong street, yeah.
You're one block off.
You're close.
Oh, I mean, 36.
Characteristics of the home and the fixed trees in the home and what he's working with.
Right here.
This one?
Yeah.
Can you zoom on this?
So, where's it at? Right there?
It's right here. Right there.
Right there, yeah.
Can drop that.
Does the vehicle run?
It's actually currently no. There was an insurance claim. I know, but actually they did just settle his civil attorney, the insurance claim with State Farm for the money to repair it. They just needed a couple things, air pumps or something. But he settled the case just recently. The home you're looking at right there is the next door neighbor. His home, on the other side of the Airstream. Oh, I see what you're doing. If you can move to the right, you'll see. Well, that's the road. And as you see, it's a short, very short section of the road there. Not many homes there at all. So there's the home. The other side driveway is the home next door. There's no room on that side of his house to comply. And then on the side the Airstream's on, it's hard to see, but there are trees on the side there, and there's no room on that. They're right there. Those trees, and they get even bigger going back, go in a straight line down the side of the house. And these trees you're looking at in the center of the screen are bigger even as you go back. And that goes all the way back down the side of the house. You'd have trouble getting a motorcycle, maybe even a bicycle back in that space. The other side, there's no space. And it's not, like I said, something that's been, he's used and had that long in that area, you would expect it to look rusted out and nasty, but he keeps it clean. He's got tire covers on it there. So, I mean, it's in good shape. It's not rusted or anything. So, but that would be a weight off his mind and what to do with stuff here. And he could focus on getting it running again with the money he's gotten from the insurance company, and go from there. So that's what I have for the board. And again, unless there's any questions, thank you. Thanks for.
Thank you, Mr. Trisler. At this particular time, I'd like to hear from the city. Caldwell, please.
Petitioner William Mike Todd has submitted an application for a variance to park a recreational vehicle in the front yard at 502 35th Avenue South. Section 23-113 states that no major recreational equipment shall be parked or stored on any lot in a residential district except in a carport or enclosed building or behind the nearest portion of a building to a street. Staff recommends that the board review the variance application in section 23-113.
Thank you, Ben.
Yeah, one real quick last thing I wanted to point out, I neglected to say, is that I truly don't think that the city would have a problem with people all of a sudden everybody parks there that wants to park it in the front, because everybody could not make the same argument here. These trees and the way he's had it there for 33 years, there's enough unique points here to him that I do not believe open the floodgates. He cannot park it where the ordinance says. Could not. He's not asking to do it as opposed to there, but he could not put it there. And for that reason, I don't think it's a snowball effect at all.
Mr. Truslow, are you familiar with our ordinance for the zoning board, the parameters we have to make our findings within?
Just generally. Not.
Okay, because you have to show proof of unnecessary hardship, and it's not sufficient. And I'm going to read from you from our section, from our code section that we're bound by. It's not sufficient proof of hardship to show that greater profit will result if the variance were granted. The hardship complained of cannot be self-created. And it must be a hardship on the property. So, and by the property, it means the land.
Right.
So
every one of those trees would have to be hacked down all the way back. And that's certainly a damage to the property, and a hardship of a senior citizen with fixed income to pay for 20 trees to be taken out.
But it's self-imposed.
Well, yeah, I suppose you could say he purchased it. You're correct, right? And he purchased it based on having that nice driveway there, and he wasn't familiar with it. But you know what? Everybody went along with him for 33 years. I mean, if you really think about it, you know, in addition to trees and everything else, I mean, he has lived his life as, you know, as far as life as we get, 33 years after he bought that, using it and having it and moving his artwork around and parking it there with no issue from any person, much less the city.
Have you recommended him taking his insurance proceeds from his insurance settlement and finding a place to store it?
He'd rather get it fixed. Now, I understand that point, but you know, it's kind of a temporary fix is why we ask for variance, because if he starts to store it somewhere, depending on his life expectancy, I mean, he's gonna run out of money doing that. And he won't have the money to repair it. Which, I mean, that's something he could do.
I know you, and we cannot, our statute also says that we cannot consider other things like other people in the neighborhood that might have the same problem. And we can't say, well, somebody else has a motor home and therefore we made somebody else move theirs, therefore we have to make you move yours, or therefore, or they already have a storage building, therefore I want a storage building. You know, we can't consider other things that are on people's land, but you know, again, our statute says the granting of the variance requested will not confer on the applicant any special privilege that is denied by this chapter on other land, structures, or buildings in the same district. And I can say to you that we regularly, on a regular basis, have people come in front of us, our board, because they bought a new truck that won't fit under their carport, or they bought a golf cart and they want a shed to store their golf cart in, and there's nowhere on their property to store their golf cart, and they need to build a shed, or their garage is full with their cars and their golf cart won't fit in their garage, or they have a boat that's too big to fit in their garage. And my personal opinion on all of this, and it may not be the opinion of the board, is that this is a stuff issue. Too much stuff is not a hardship. You know, if your boat's too big and it won't fit in your garage, you store it in a storage yard like other people. If your motorhome is too big and you cannot get it behind your house, you go store it somewhere. And otherwise, we would have motorhomes and property all over in people's front yards, all over the city. We would have boats in people's front yards, jet skis. And the purpose of zoning is to provide a uniform appearance throughout the city that is pleasant to everyone. And I don't see how Mr. Todd's wanting to keep his motorhome in his front yard makes him any different or any more special than anybody else.
I think there are some things. I don't think you're going to have what you said with all the people trying to put stuff in their yards. I think it's a real difference here. I think that separates him from all those requests. I think he's differently positioned. I think his property is differently positioned than all the other people that come before you, because he's had it there 33 years. He cannot put it anywhere else.
He can put it somewhere else. He can move it to a storage yard like everybody. There are storage yards all over town where people keep their boats, their jet skis, their motorhomes. He can put it somewhere else.
I would not agree that he can. Really. I mean, it doesn't come free. I mean, he's using his property to the best and most he can. He's on a very fixed income. He's ill. You know, it would probably cost him more to cut out all the trees to put it on the side of the house.
Mr. Truslow, with all due respect, I'd like to move this along.
Oh, sure. I have nothing further on it that I have said.
I believe we've given you every opportunity on behalf of your client to argue your case. Would like to see us move forward to make a deliberation and decision on this.
I understand.
Yeah, I would like to speak on this, please. Amy McCaskill.
Go ahead.
Yes. When my cousin received the letter from the city,
I'm
You
sorry.
the longest-
husband is Mike Smith, correct?
Now, before Ms. McCaskill speaks, she's gonna have to be sworn in, and I think Allison was attempting to do that.
I'm
So
sorry.
Allison,
Yes.
if you would please swear Ms. McCaskill in.
Please.
Yes, Ms. McCaskill, do you solemnly state under penalty of perjury that the evidence that you shall give in this issue shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Thank you. Go ahead, Ms. McCaskill.
Yes, I am the reason that this all came about, because a renter down the street from him, the family of this renter down the street from him, was putting their dog mess in his trash can. And I know this is going to sound like something out of a bad reality show, but I mentioned it to this person's wife to please not do that anymore. And this letter came about within weeks of that. No one has said a word to my cousin since 1988, 1987, when he bought this. And it's not true that he would have something that other people don't have. There are over 300 violations of this code in broad daylight in everybody's neighborhood in this town. And I'm talking about wealthy people. I'm every kind of people. It has not been questioned with them. And you saw, it's the first time in 10 years, in October of last year was the first time in 10 years that this code had come up before this body. I'm only going by the minutes that are posted on the city council website for this board. I don't know that it's ever come up before that, but it is not enforced until someone complains. And I know that Mr. Quinn in the October meeting questioned about why there were so many people on 39th Avenue that were cited at the same time. And it was also a personal issue when someone turned in 3 people on that street to get at one. Those people got an audience with 4 city administrators, including Mr. Bluss, in that meeting. And Mr. Bluss or one of the zoning officials came to their homes to try to help them figure out what to do with theirs. My cousin got this letter, and it was different from the letter that one of the other persons received. This one had, the violation language in it that talked about the fines, the daily fines, and that no one else got. And it is just heartbreaking that this man he had a stroke in 2016, and he is trying hard to come back to life as he knew it. It is going to be hard. He's an artist. He used this vehicle to transport his art. He's got heavy sculpture in his house that he transports with this too. And when he got this letter, I'm not exaggerating, every day since he received this, it is breaking his heart a little bit every day. And I'm the one who caused it, just because I said to someone, don't put your dog poop in his Pelican, please. And in the case of the people on the street, 4 streets over, someone saw that her ex had bought a boat and she didn't like it. So she turned him in and 2 more people on the street, I guess, so it would look like she wasn't picking on him. I mean, I just, I wouldn't have even learned all this if I hadn't done numerous Freedom of Information Act requests to the city to find out who even made the complaint against my cousin and the other people who this happened to along the same time. And I would just say he's 70 years old and his health is not good. And the idea that right now, because of what I said, this is going to happen to him is horrible. And I just, needed to say that.
Exactly.
There are 300 examples of boats, trailers, and RVs. There are not as many RVs, of course, but ride down any street in Cherry Grove and tell me that you don't see this code violated. I mean, it's in broad daylight, and these people are everybody's neighbors. So to say that it's not, this is definitely selective enforcement. I mean, in that meeting in October, I said when Mr. Quinn even asked what Mr. Bialecki was doing at the meeting, what he was presented, he didn't even know what it was because this doesn't come up. This is only enforced by complaint. And the idea that there are sweeps going through the neighborhood, Mr. Bluss countered that was not true, that there were sweeps going through the neighborhood. They're trying to clean up. It's only when someone complains is there enforcement of this code.
Miss
It was not offered.
Miss Gaskell, hey, this is Billy McGonigal. We come across these all the time. And as soon as we start making selective decisions, you said a minute ago, hey, selective. We didn't. They had to move the vehicles, they had to move the boats, they got to move them where as required by the law. As soon as we start making special exceptions, we no longer have any rules. And I understand the feel for you, but the problem is we've had people all over the place come in and they give us, as Ms. Lover said, they give us the reasons why they have too much stuff and nowhere to put it. And it's a difficult chore. We can either have rules or not have rules. The case is, we do. Let me finish, please. And then we listen to you. We, as they bring it before our board, we try to follow the parameters that are set before us and do the best we can with following them evenly and fairly. Those people that you talked about, they dealt with them and they had to modify and do what they had to do to meet the requirements. The same as over by Miss Lover, the same situation over there. Over where I live, the same situation. So that's what we're tasked with. We're tasked with trying to evenly follow the rules and the parameters that we have before us.
Yes, but those people were able to back their vehicles up a few feet. That's what they had to do to comply, sir. I'm just saying, this man is part of the reason that Highway 22 doesn't come into the North Myrtle Beach neighborhood now. He was responsible for getting roads paved in his neighborhood. And I mean, he was an activist in bettering the city or his part of it. And I mean, the idea that he is, I mean, I see what you're saying, but no one, I know in that meeting that, board members encourage people at that meeting to turn people in, and nobody is turning anybody in because they don't want to have to move their equipment. I mean, the idea that you bend over backward for some to help them comply, and then they're going to be campers sitting.
Yeah, that's not the case. There is no bending ever backwards. You have to follow within the parameters, and the same parameters that we have is the same parameters everybody has to fill in. So I can understand your situation and sympathize with you, but we've got a parameters to work with. So all the things that you just described, so we're not selectively doing it for this neighbor I like or this neighbor I don't like. We're following the parameters that are set before us. And sometimes we've got to give answers to things that are, make some people unhappy. But we do our best. And when you say that, as soon as we start bending these rules is when we no longer have rules.
Amy, I think you said about it, everything. I mean, you got it across and what you wanted to say. And I just want to tell y'all the last thing I want to say before you vote as we end, I just want to tell you, and I haven't been in front of this board before, and it was an experience. And thank you, and thank you for listening. Let us present. Yeah, the only last thing I would say is that I understand it's got to be a difficult job. Everybody wanting to do that, and I get it. And I hear people I know in my neighborhood that they go and ask for this because they need to move it here. But under that ordinance, the behind the nearest portion of a building to a street, that is not present on his property. His property does not have that. And I just only want to close with that because I think that's the distinguishing thing. And so I didn't want to get off on all the other issues because I know those are the ones that you can empathize with, but you got to do your job. I get that. But I do want to make the point. He does not have what is required in this ordinance to use. So it is, I think, an issue of uniqueness of the property and a variance to deal with that. That's my position. And I just want to thank y'all again for your time. Thank you.
Mr. Lowe, and thank you, Ms. McCaskill, for your commentary. Is there anyone else to speak to this particular request before we go ahead and deliberate? Anyone else? All right. I'd like to ask for a call for a motion at this time.
I'm prepared to make a motion.
Okay, Ms. Lowe.
I would make a motion to deny the variance request portion of variance D03-20 based on the fact that the applicant and petitioner has failed to produce proof of unnecessary hardship, and that the hardship was self-created.
Okay, we have a motion. Do we have a second?
This is Billy McGonigal. I'd like to make a second.
All right, we have a motion and a second for the denial. Any further discussion? There being none, all those in favor, please signify.
Aye, Billy McGonigal.
Thank you. Bill.
All right. Roger Quinn.
Thank you, Roger.
Ray Skidmore.
Thank you, Ray. Dan Moore. Looks like it's unanimous for denial. Mr. Truslow, your request has been denied.
All right. Thank you for hearing it.
Thank you.
It was an experience. Y'all have a good day.
All right. Next item on the agenda tonight is item E, variance B13-20. Our Lady Star of the Sea Catholic Church has made application for a variance to erect a second freestanding sign on the property at 1100 8th Avenue. The second sign is 32 square feet. Mr. McCluskey.
Yes. May I just interject here?
Excuse me?
Mr. Chairman, before we proceed,
Yes, sir.
may I just interject? I don't believe there is a conflict of interest, but I do attend that church. I looked at the conflicts of interest, the regulations, and I don't believe at this time I have to recuse myself, but I did want to present that to council.
Okay, that sounds good. I believe that's correct. All right, at this time, Mr. McCluskey, before you begin, we'd like to have you sworn in, please, by the city clerk.
Okay.
Ms. Galbraith, would you swear in Mr. McCluskey, please?
Mr. McCloskey, do you solemnly state under the penalty of perjury that the evidence that you shall give in this issue shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, Allison, and thank you, Mr. McCluskey. You may proceed, please.
Okay, we have a sign currently at 1760 Livingstone's Lane. At our previous location, we had a school there.
Yes,
2018, we were flooded out and had to relocate to Our Lady Star of the Sea Catholic Church here on 11th Avenue or 8th Avenue. And apparently we wanted to move the sign from that location to this location. And the sign is approximately 8 feet wide by 4 feet high.
Yes, sir.
And I do had some pictures I believe I submitted,
Yes, sir.
showing that.
We do have that. Now, this is the school.
Correct.
operate. This is the directional and or advertising for the school.
Yeah, what it is the school is now located physically on the church property.
Exactly.
And the church itself has a sign out on the Highway 17, but we were instructed we had to have some type of sign indicating that there was a school here for fire regulations and that type of thing.
Okay, do you have those evidence of that information in your request?
I do not.
Can you, I mean, you can provide that. That can be provided.
As far as the fire marshal request,
Yes.
I don't know. Karen, do you have any information on that? I believe she's on here as well.
I am. I'm the principal at the school. I don't know if I need to be sworn in before I speak.
Yes, ma'am. I'd like to ask Ms. Galbraith, Allison, would you swear in Ms. Luzzo, please?
Ms. Luzzo, do you solemnly state under penalty of perjury that the evidence that you shall give in this issue shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, thank you both. Go ahead, Ms. Luzzo.
When we first relocated, we of course had our walkthrough to make sure that we were complying with all of the regulations we needed to. And the fire marshal did instruct us that we needed to have a sign on the property indicating the school in case there were an emergency, they would know where to find us. I don't know that that information was submitted, but we certainly can provide that.
So, okay, but you definitely can provide a statement to that effect
Oh, yes, sir.
from the fire.
Yes.
Okay,
Right.
all right.
Plus, we would also like the sign simply because no one knows our new location is here. And so it's hard for us to let people know that we're here, that we're in this new location.
Okay, any other supporting information between you, Ms. Luzzo, or Mr. McCloskey? Anything else?
I don't think so.
Okay.
No, I don't think so either.
All right. We'll go ahead and hear from the city and then we'll get back to you. Hold on, just hold where you are.
Thank you.
Petitioner Doug McCloskey has submitted an application for a variance to allow a second freestanding sign. Within the highway commercial district, properties are allowed one freestanding sign. The applicant is asking to be permitted to erect a second freestanding sign within 32 square feet. Staff recommends that the board review the variance application, hear the evidence presented at the meeting, and review section 2336.
Chairman Moore, this is Allison again. I need to swear in Ben and also Paul as well.
I'm sorry, Allison, you're correct. Gentlemen, if you would go ahead and let Allison swear you in, please. Thank you.
If you raise your right hand, do you solemnly state under penalty of perjury that the evidence that you shall give in this issue shall be the truth, the whole truth, and nothing but the truth?
Thank you for reminding us, Allison. Thank you. Okay, questions from board members of the applicant and the request? Will entertain.
So if you were not allowed to have a sign, then can you not get a certificate of occupancy? Can you not go forward with a school with that location?
I believe we do have a certificate of occupancy. It was just when the fire marshal came and did his walkthrough. If I'm correct, Doug, you can help speak to that as well.
That I don't know. I can't really respond to that.
I mean, I think we do have a certificate of occupancy. That's not an issue. We do have that. It's really more a matter of
Safety concern.
letting people know that the school is even there.
And a question for the city, if the sign is not freestanding, then can she have it? If it's attached to the building, is that different than a freestanding sign, the rule?
Yes, a building sign is different than a freestanding sign. However, I mean, I don't know what the church has overall and what the ordinance says on that as to what the overall signage would be. We advertise that they're adding the 32 square feet as a freestanding sign. But the wall signage is considered different than freestanding.
I was just curious, if she had just a sign on the building where you go into the school, then would she need a variance?
Maybe not. I haven't looked at that, and I don't know what the total square footage is of the property.
Ms. Luther, do you have any information regarding whether the sign would work on the building?
The reason we're requesting one on the road is because the entrance to the school is set so far back from both Highway 17 and 8th Avenue. There's a whole paver parking lot between us and those roads that is the issue with people even knowing that we have a school there. The church sign is out on 17, but there's no indication that the school is there, and there's such a distance between the road and the entrance to the school.
Ms. Lover, going back to your question, I'm pretty sure the signage for the church is maxed out and they need a variance for the 32 square feet, even if the sign went on the building. They did replace that sign. It's probably been 10 years ago or so now, or maybe even longer than that. But they did replace their old sign at the church, and I think they maxed it out. So even a wall signage would need to be before the board with a variance for that square footage.
So even if they added a sign to the sign, the one freestanding sign that's there for the church, even if they added some sort of a plaque underneath of it or somewhere thereon saying the name of the school, they would still have a variance. I'm just trying to figure out a way that they can do this without needing a variance.
I honestly don't think they can do it without a variance. And if you're not talking about the freestanding, we're talking about the square footage.
Okay. Anyone prepared to make a motion?
How about asking them to postpone until I can come up with some reasonable way of meeting the regulation?
I don't understand the question, Roger.
I think, Mr. Quinn, there's no reasonable way to meet the regulation. They would need a variance.
May I say one more thing? The reason that we were asking about this sign, which I believe we provided photos of, was because it's a special sign that was donated by donors of our, to our school. So we were trying to reuse that sign in lieu of having to purchase a new one, and also to honor the people that donated that sign to our school.
Hey, Paul and Ben, question for y'all. This is a big piece of property. I mean, you think they would get some sort of relief? We're bunching it all together, but I mean, we got a big piece of property. Is there any relief there, Paul? I mean, Ben, give me your thoughts.
There's no relief. Ben suggested they could just put a entrance sign out there, which they can do. And there would be no variance needed for that, but it just say that the entrance to the school. In this case, if you're looking at it is a little bit unique in the fact that it goes across two different zoning districts. The highway commercial is out by the highway where the other sign is at. And I'm not sure where the line runs through the church itself between highway commercial and R2, but the entire back of the property is in R2. I will say that in commercial situations, if there's more than one building on the property, if it was a commercial, let's say shopping center, and there was more than one principal building on the property, and it's got two street frontages, the city ordinance does allow two freestanding signs. The smaller sign would be on the secondary street, which is similar to what they're asking for now. It's a 32 square foot sign versus 150 or so out by the highway. But that's a commercial situation. It doesn't necessarily apply to this, but it was a situation where council looked at it at one time and said, well, there are some differing situations on corner lots where there's more than one building. Don't know if that helps or not, but that's the only difference I can come up with there, Billy.
Yeah, that does. I mean, when you look at this and another application, that's what makes it exceptional, extraordinary. The size of the property, multiple things going on. And then we throw in the factor of the multiple districts. I mean, you feel like this is why we're here, for looking at those extraordinary circumstances, or unique circumstances, rather.
Well, that should segue into making a motion.
The other point is that there are times when you can place conditions on variances and grant partial relief because what you're trying to do is in the greater public good. In this particular case, we have children attending a school, but that's just my opinion. Thank you.
Mm-hmm. Well, I'm prepared to make a motion.
Go ahead, Billy.
I'd like to make a motion that we approve variance V13-20 based on the conditions that it is an exceptional, it's a larger piece of property, multiple functions going on. What makes it unique is the size of the property, the multiple zoning districts. I think by not putting the sign in there, you don't allow them to unreasonably use the property to direct people where they need to go. I believe it's a minimum variance. I believe it hits that as well. And that should complete my motion.
All right, thank you, Billy. We have a motion. Do we have a second?
Ray Skidmore will second.
Ray Skidmore, second. Any further discussion? There being none, how do we vote?
Billy McGonigal, aye.
Thank you, Billy.
Ray Skidmore, aye.
Thank you, Ray.
Roger Quinn, aye.
Thank you, Raj.
Cynthia Lover, aye.
Dan Moore, aye. It's unanimous. 5 ayes, no nays. Motion carries. Your request is granted, Ms. Lozo.
Thank you so much.
All right, have a good
Okay,
evening.
Ms. Lozo, and Mr. McCloskey, this will require a sign permit. So when you get ready to move the sign or erect it, you need to just make application with the city.
Yes,
Okay.
sir.
Okay, thank you.
Have a good
Okay,
night.
thank you very much.
Thank you. Have a good evening.
Thank you.
Thank you.
Next item on the agenda tonight is G variance V15-20. Mr. Jeff Kaiser, how are you tonight? Jeff, you still with us? Not taking a nap or anything? Okay. Has made application for an 8-inch reduction of the required 5-foot side yard setback in the R2 medium density residential district, 506 Hillside Drive South.
Can you hear me?
I can. I need to get you sworn in by the city clerk. Mr. Kaiser, please. Allison, would you swear in Mr. Kaiser?
Yes, Mr. Kaiser, do you solemnly state under penalty of perjury that the evidence that you shall give in this issue shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Thank you, Allison and Mr. Kaiser. You may go ahead, Mr. Kaiser.
I'm requesting the variance of the 506 address to, we're trying to do an addition onto this house, 5 feet more. Well, we would be demoing the lean-to. There's an old addition. I'm not sure when that was built, but the older addition juts in a few feet on either side, and it has very low ceilings, and it's leaking. We've patched the roof. It's just they want to reuse can you still hear me when someone's calling me?
Yes. We've got your voice.
All right. So we're trying to add on to this house, and we're not trying to, I guess the setbacks is limiting us to have the overhang of the roof. So it's more of an aesthetics issue when adding on to this house, that the overhang, the soffit, the fascia overhang of the house continues and flows with the house. And I've spoken with the neighbor. They're not opposed to, they're aware of the situation. They're not opposed to the soffit encroaching on the 5-foot setbacks that is on the property. So we're proposing to add on to the house, and that it's approximately 11 feet worth of soffit to be over the 5-foot setback. So the foundation of the new addition would be right on that 5-foot setback, but the overhang of the new part would encroach on the 5-foot setback.
8 inches is your ask, right?
And so they're trying to. We have plans. I didn't submit any. I didn't submit for a permit because the architect and I were well aware that it was going to encroach. The overhang was going to encroach. So we're just asking for that variance before we even apply for the permit and submit the plans. But we're trying to, the homeowners, they live in Texas now. This is the second home for them, and they're trying to move here permanently. And in the new section, they want to add a master bathroom. He's going to have an office there. So we're just asking for the variance to not build over the setback, but just the overhang is over it. And that's pretty much it. Say that again.
Total of 8 inches.
Yeah, 8 to 12 inches. It's gonna match whatever the existing overhang is, which is around 8 to 12 inches. Yes.
Questions, board members?
I guess my question would be, why can't you just build it 11, just make the walls 11 inches inward? Why do they have to be, it seems to me you're talking about a foot. So why can't you make your building 1 foot smaller?
Because we really want to, the roof line of the house is on the front of the roof on the front of the house is a hip roof. And on the back, we want to continue that hip straight on out, and bringing the footprint in 11 inches is going to make a funny design from aesthetic standpoint. And we have to have you have to have the overhang for the building purpose. And so the answer to your question is so that we can. It just is an efficient way to do the roof, to just continue the foundation of the house and extend the hip of the roof, just continue it straight back in a smooth transition versus do a lean-to kind of what's there now.
I guess sort of my confusion with it is I'm going back to that property 3 times and stood in the backyard and looked over the fence, trying to figure out what exactly it is you wanted to do. And that's sort of my, I guess it's sort of my concern is looking at the house. I don't know exactly what it is. There's a porch back there. Are you taking that porch down? Are you building over the porch? I can't figure out what it is you want to do.
Yeah, so all that is going to have to come down for us to do the continuous footers, and from the back profile of the house, it's just going to be a standard hip roof. So the ridge line is just going to continue. We're extending the addition now is, or the lean-to that's there is 6 feet. And we want to add 5 feet to that. So it's going to be extending the ridge line like 11 feet. Well, not even 11 feet because it's going to hip in the front. So it's going to change the look of the house. It's going to become a true hip from the back.
Mr. Kaiser, I think you just answered the question. That was some of the similar questions, Ms. Lover, that I had as well. Or how far back on the, gosh, maybe I missed it. What is the setback on the rear?
The rear is here. I can show you here. Is 50 feet.
Go straight, 25.
Right here, that's 50 foot in the rear. So we got plenty of room in the rear. It's just the right side of this property it was built right on the setback. The foundation is right on the 5 foot setback. So the overhang is over it, and just for aesthetics and efficiency building it just makes sense to just continue that roof line on back and extend the foundation of the, not including the lean-to, the addition that's there. It would be extending the foundation 11 feet and just bringing the roof line all the way over.
Now, are you are the lean-to? So you're going to pretty much square this house off. If you were going there to do it, you do it right, so you don't have a zigzag and all that. You're going to square the house off, and the roofs. It's going to pretty much conform with the existing house itself.
Correct. Yeah, the roof line is going to go. The sides are going to be seamless, and then it'll hip down in the back. So we won't have these step ends on either side.
Okay.
And the house that's there now is currently in compliance. It's within the setbacks. You're not making the house there any bigger. It's just going to have a little overhang on the eave.
Yes, correct. So it's not, the foundation is not going to encroach on the 5 foot setbacks. It's just the overhang of the roof. And like I said, I spoke with the neighbor and they're well aware. I explained everything to them, and they're interested in doing the same thing maybe down the road. So he was definitely not opposed to bringing the aesthetics up of the house, because we've repaired the roof, and it's of the lean-to, and it's just it needs to go. And when we go back, it just is the most efficient way to build it.
That was my question earlier, and I guess my video got taken away, and now Paul's not in the room. But looking at the survey, I see the original footprint of the house is right on the property line, which means that the existing overhang would be encroaching on the setback. So at some point, I'm assuming they didn't used to count overhang, they just counted the body of the house. Is that correct, Ben, or is that a Paul question?
No, when that part of, or when the ordinance that didn't allow overhangs was put in, but any idea on the age of this house?
I mean, here on the survey, it says effective date of 1988 is when, that's kind of referring to when this survey was put into the floodplains or the flood zone.
Yeah, 94 is on the bottom of the survey.
Yeah, 94 is I'm guessing when the homeowners purchased the property or when the survey was done. The house is really old.
Paul, I got a question as to when we put in the ordinance not allowing overhangs in the side yard. Prior, was there?
I'm not sure on the question of that. As far as I know, we've never allowed the overhangs into the side yard. And the ordinance we passed in 1988, we did allow the overhangs then to go into the front and rear, but we didn't change the sides. So what we did over the years is basically just make it a little bit more lenient on the front and rear, but not on the sides.
So the house was never in compliance.
To my knowledge, if it goes into the setback right now, it was never in compliance.
That's because that's original.
And it being an old house, it was probably built according to some standards that weren't even North Myrtle Beach at the time, maybe Ocean Drive.
60s or 70s.
I do, can I add something?
I'm sure.
Sure.
I do know the house was oceanfront and it was moved. I think the house is definitely older than 1988. That's just when I think that's when the flood zone. I'm not sure exactly, but I'm almost positive that the house is older than 1988. And I do know it was moved from oceanfront to there.
But somebody with either the city of Ocean Drive or the city of North Myrtle Beach would have signed off on it when it was put on the property.
Yes, it should have been, yes.
Oh, it says the date here, 1953.
It's old time. Okay, thanks.
Well, I take it back. If it was done in 53, we may not have had anybody in Ocean Drive checking that sort of thing.
We weren't a city.
Except for Merlin Bellamy.
Yeah. Chief Bellamy. All right. Any other questions? Let's move it along.
Okay, so it just seems to me like he wants something that's already there, but it's not allowed by the current code. But at some point in the past, it was approved because the house is there. Is that correct or not?
Sounds correct to me.
Yeah.
He's not really asking for anything new. He's just asking to make what's already there nicer.
Correct.
I agree.
All right. Anybody prepared to make a motion?
Miss Lover, you want to keep going?
Oh, sure. I'll make well, wait a minute, let me find it. What's the number? I don't know that. Hold on. I got papers everywhere.
B 15-20.
15-20.
I'll make a motion. We approve variance B 15-20 on the grounds that the variance requested is something that is already on the property and it's just an improvement to an existing. The variance is being requested is an improvement, an upgrade, say, to whatever is already there. We're not really conferring any new or special benefit on the applicant.
Okay. We have a motion. We have a motion for the approval of the variance. Do we have a second?
I second. Ray Skidmore.
Ray Skidmore, second. Thank you. Any further discussion? There being none, all those in favor, please signify.
Aye, Billy McGonigal.
Thanks, Billy.
I Ray Skidmore.
Thanks, sir.
Aye, Roger Quinn.
I, Cynthia Lover.
Aye, Dan Moore. It's 5-0. It's unanimous. Your variance has been approved.
Thank you. Thank you for your time. I appreciate it.
Okay, thank you.
All right.
All right, last item on the agenda tonight is
Mr. Moore, before we go to that, can we address the issue of variance B -20? And Mr. Richard Neff, and you staff has indicated did we say that for the record?
next item on the agenda tonight really is item F, variance B 14-20. Mr. Richard Neff made application for variance to remove a tree in excess of the 24-inch caliper measurement at 4608 South Island Drive. It appears, according to the zoning administrator, that Mr. Neff has withdrawn that application at this time. Do we don't need to do anything
No, it's just been withdrawn. It's just I guess for the record.
for the record? Okay. Thank you for that. Thank you. Okay, back to the final item on our agenda tonight. I know Mr. Shattuck has been waiting anxiously. Variance B 17-20, Mr. William Shattuck made application for a variance of 4 feet and will require 20-foot rear yard setback. Single family 1104 Inlet View Drive. Mr. Shattuck, I'm going to ask the city clerk to swear you in, please. If you
Mr. Shattuck, if you'll raise your right hand, please.
please, thank you.
Do you solemnly state under penalty of perjury that the evidence that you shall give in this issue shall be the truth, the whole truth, and nothing but the truth?
Do.
Thank you.
Thank you, Mr. Shattuck. Thank you, Allison. You may proceed, Mr. Shattuck, with your request.
Appreciate your time. I'm kind of new to meeting with a board such as this. We are a new homeowner. We have purchased a new home. We've been a resident of North Myrtle Beach since last July. We are trying to simply add a screened patio to the rear of our home, which ties up to the back of the Tidewater property. There is trees behind my house. I'm trying to get a 4 feet variance to allow the footings to be put in for coverage of the current cement patio that exists today. I have, I did believe I still have my contractor on the phone. Mr. Hayes, are you still with us? I'm not sure if he's left us or not. Ms. Lover was nice enough to come and visit with us today. I appreciate her visit, and she did review the area in which we're trying to just simply put on a small addition for a screen-in patio so that we can sit outside and not be attacked by the mosquitoes of North Myrtle Beach.
Mr. Shattuck, is your contractor Kenneth Hayes?
Yes.
It looks like he's on here.
That's me. I'm here. I had myself muted. I apologize. I just figured out how to unmute my mic. This is my first Zoom meeting.
Okay.
So.
Thank you.
We will need to swear Mr. Hayes in if he's going to offer any testimony.
Yeah. Ms. Galbraith, if you would swear in Mr. Hayes, please.
Yes, sir. Mr. Hayes, will you raise your right hand, please?
Yes.
Do you solemnly state under the penalty of perjury that the evidence that you shall give in this issue shall be the truth, the whole truth, and nothing but the truth? Thank you.
Thank both of you. Okay, Mr. Shattuck, you want to proceed? You want your contractor?
Again, I'm not sure if Ken might be a better source of explaining how this will cover the 4 feet variance.
All right, Mr. Hayes, you want to go ahead?
Yes, sir. Essentially, what we're looking to do is build a screen porch along the existing concrete slab that's there. However, in the back of the house, there's a 20-foot rear setback, which goes about 3.5, almost 4 feet into that concrete slab. Had the builder built the house slightly forward, which he could have done because there's a 25-foot front setback on the property, he could have moved it forward about 2.5 feet and given us enough room to build the screen porch. So the house was built without a screen porch, and the lot, the way the setback is in the back, not really sure why they did a 20-foot setback back there. There's no golf course or any kind of lake or drainage easement or anything like that back there, but there is a 20-foot setback. So in order to be able to put Mr. Shattuck's screen porch on the back of his home and not have it be 7 feet, it'd have to be 7 feet from the house, like to utilize the full 10 feet of the patio that's already there.
And there are trees behind us. There is no one residing behind us whatsoever.
That's right.
What is your hardship?
Well, hardship would be the fact that the patio was already poured. It was already set there. We always anticipated, and we're told by the builder, yes, you could simply screen it in until we determined that it was a request for a variance. So we had no knowledge. We bought one of the last few homes in this Watergate development, and it was not already screened in, as many of my neighbors that already have set, and were all constructed before they bought the house.
All right, anything else you have to offer as to that being a hardship?
Well, it's just, I mean, the hardship, I guess, again, and I don't mean to make joke of it, is that, you know, this is after working for 49 years, I'm about ready to retire in December, and wanted to simply have a screened in porch so we could sit out and enjoy in evenings and not be eaten up by bugs and mosquitoes. And I just simply want something screened. It won't be it's not going to be a sunroom or an all season room. It's just simply a screened in patio.
All right, anything else?
I'd also like to add that when the house was built by the builder, it was an option to have the screen porch on there. And I believe Mr. Shattuck bought a spec home that was already built, so they didn't have one on there. So it would have been an option had he spec'd out the house, and then the builder probably would have made sure to keep it within the setback lines and move the house actually forward a few feet to do that.
Right.
So, you know, now he has no out, and they was told that he could add a screen porch after the fact. I guess they didn't realize about the building setbacks or whatnot, but he was told that he would be able to add a screen porch with no problem. And then that's when he called me and a couple other contractors, got some prices. And when I looked at the survey, I realized there would be an issue. So
Be careful when there's no problem. Okay.
Correct.
All right. Questions? Other questions?
I have comments. Mr. Moore,
Yes, ma'am.
did everybody go visit the property?
I did not.
Okay. I would just say that I did go out, I looked at the back of the, I went to his house, looked at the backyard. There's an 8-foot chain link fence running. There's a bunch of houses in a row. There's an 8-foot chain link fence running down the back of this property line, the length of the project. And behind it, it is heavily wooded. And looking at his house, I observed that his house is in line with all the other houses in the row going down the line. You can stand at his back porch and look. There's one house that is set in. I think one of his neighbor to his right is set in some, so it has more land. Then the neighbor to his left, they do have a screened in porch, but it's built into the house itself. Instead of making where whatever the corner of that house, whatever room's in the corner of that house, they built that into the house. There are no other porches or decks or anything protruding down that property line for all of those houses in that development on his side of the street, as far as I could see. And my take on it from looking at it is that the developer maxed out the property, maxed out the setbacks when he built these houses so that he could build the biggest house he could build within the setbacks for this zoning designation. I'm not sure, is it R2 or R1 something?
R1B.
Okay, so my take on it is that the developer built to the max, the biggest house he could build on each of these lots, and he could not have added a porch onto the back of these without making the houses smaller. Because, and so whatever he may have told him, I don't know, but the house beside him does have a screened in porch. However, the screened in porch is within the confines of the house itself. It's not protruding out back it's not protruding into the rear yard of the house. It's within the confines of the walls of the house. And I think that when the developer built this, again, he built the biggest houses he could build so he could sell them for as much money. He could have put the house, I don't know if he could have put it more forward or not, because I don't know what the front setback is and where the house sits with regards to the front setbacks.
4 feet.
But basically, it's my takeaway from this is that the applicant's asking for something that the builder could not have gotten when he built these houses. the builder could not have put a screened-in back porch on each one of these houses because he would have been into the setback on all the houses. Is my take from looking at it.
Okay.
Ms. Love, I will tell you that this model that I bought, and it was a spec home, it was already completed. And like I say, it was like 3 houses left in the whole community, is the smallest model that this builder built in this development in square footage. And to Ken's comment of earlier, there was a 25-foot setback. The house could have been brought a lot closer to the street had I known, or had the builder known, that this was going to be an issue. I certainly understand what you're saying, but it's simply just a need for 4 feet. And there's nothing behind it that's going to be destructive. I've checked with neighbors. No one has any comments or disconcerts that I can't do it. That I would be able to do this. And I also, prior to this, had to go and get our HOA approval, which I got in February.
My guess would be, and again, this is only a guess and an opinion, that all your neighbors don't have a problem with it because they want to do the same thing. I mean, that's just totally my guess, but the zoning is, we see this in zoning because people buy a house, then they want to build onto the back of it, and then their neighbors are right up against their fence. It just totally defeats the purpose of the zoning when we allow something like this, because this is a newly built development. It was all built within the confines of the zoning designation, and giving a variance, in my opinion on this, defeats the purpose of having the zoning in the first place.
Well, there was one home, ma'am, that down further that I did show you that they are adding on in the same variance that I am. I don't know whether or not they did so illegally or they did it on their own, but there is one under construction down there. I understand variances. I understand the rules. I'm a black and white person. I totally understand that. But had I known that this was not going to be a situation, I probably would have bought someplace else. Now I'm kind of engrossed in this neighborhood and running for a board on the HOA for board director myself. It's just been real hard. That's all. I just simply want a little patio so I can sit outside and not get eaten up by mosquitoes.
And I understand what you're saying. You seem like a very nice guy, and I understand. I'm not trying to give you a hard time per se. I'm just saying that's my take on it from going out over the years and looking at numerous developments, numerous zoning requests and variance requests. That's my take on it, is that the builder could not have built onto it. And this is a new development, and you're asking for something the builder could not have built when he built the house, or he would have done it.
But the builder put a slab out there, so why would that not already be a violation in its own?
Because it's less than a foot off the ground.
Gotcha.
He put a slab for you to have chairs. You got a little slab out there, little back porch out of your sliding glass door, out of your doors there. You've got a nice little porch that holds, your chairs and some flower pots. And that's why he put that. Because if he went above a foot, if he set the post and went up, he was going to have to get a variance to do it. And the city would not have, I don't think the city would have told him he had done that when he got that development approved. Would be my opinion that if he had said to the city, I want to build in this zoning designation, I want to build all of these houses, but I want to put a garage on the back that goes, I don't know, 4 feet into the backyard, or not a garage, a deck or a sunroom or a Carolina room or a screened-in porch or a golf cart shed or whatever he wanted to put on the back, I don't think that the plans would have been approved. They would have said something else.
Hey, Mr. Blust and Paul and Ben, is there any construction that can help? You see these tubular screened structures. Is there something that he could do to enjoy the back without encroaching? I mean, and Mr. Shatlock, that's our struggle right now. We look and we try to find. We need to be consistent in our deliberation. And we've looked at these and try to find out, we want you to have a porch, but the problem is now we have a 16-foot side, back rear setback. And the next person makes it a 14. We don't have these setbacks that are set, by the city. But Paul and Ben, is there any construction that would allow, we understand he wants to use a screened-in porch. Is there something that's per se a temporary that doesn't constitute that's good? Is there anything we can work around this with construction-wise?
I don't know of anything myself. He's got, according to the drawing, maybe 6 feet. And we would allow a 2-foot overhang to go into that rear yard setback, but he wouldn't be able to screen in underneath that overhang because it's no longer an overhang if you do that. So all he's going to have is 6 feet, which he's got already without coming to the board. And obviously that's not what he wants. He wants 10 foot to make it a usable screened in room.
Yes, sir.
I don't know of anything that wouldn't be considered a structure and be able to go into that setback. As Ms. Lover said, if it's above a foot off the ground, when you start coming out of the ground,
That's where the problem is, right?
Yeah.
Mr. Shatlock, that's our difficulty. As soon as we start coming off these parameters, we no longer have rules, and I'd love for you. I can see why you want to put it. I sympathize with you and want to. We're just tied to the rules that we have.
Just to interject a little something, I do know that within the city of Myrtle Beach, which I know it's kind of sets precedent, it's not you. They have considered the lanais to be somewhat temporary, which would be an all screen structure, like a screen roof. And I don't even know if Mr. Shattuck would like that, but we have done those sometimes in Myrtle Beach, especially around Market Commons, where there's basically no setback. They will allow us to put the screen lanais, but by the code though, it is a structure with a roof. So it's supposed to comply with the setbacks, but they will allow that sometimes. I don't even know if he would be interested in that, but just throwing that out there when you mentioned like a temporary structure.
Well, if we don't have such a thing as a temporary structure, it would be a structure, and they'd have to build. They being city council would have to change the ordinance and build that in as an exception. Which obviously, if they did, that's fine. But right now, that's not within the code, and we can't do it.
Okay.
All right. Anyone prepared to make a motion?
Y'all gonna make me do this, aren't you?
You want to roll?
I'll make a motion that we deny variance B17-20. I am sorry, Mr. Shattuck, on the grounds that I do not see a hardship. And that I've stated my position earlier is I don't see a hardship with your request.
We have a motion for the denial of variance B17-20. Do we have a second?
Ray Skidmore second.
Ray Skidmore second. Any further discussion? There being none, how do we vote?
Cynthia Lover's voting aye.
Skidmore, aye.
Quinn, aye.
Billy McGonigal, aye.
Dan Moore, aye. The motion carries for denial of the variance. Mr. Shattuck.
Thank you. Thank you for your time.
And I'm sorry, I just don't see a hardship. I wish I could help you, but looking out there, I just didn't see it.
Ladies and gentlemen, that concludes the agenda for this evening. Is anything else to come before our board?
Chairman Moore, this is Allison again. Just for the record, I need to swear in Ben and Paul for previous testimony before I swore them in. So for the record, for the previous testimony that they had.
Okay, I'm sorry. Go ahead.
That's okay. It's my fault for not catching it in the beginning. Do you solemnly state under penalty of perjury that the evidence that you shall give and the issues that we have presented today shall be to the truth, the whole truth, and nothing but the truth.
I do.
Okay, thank you.
Thank you, Allison. Appreciate
Thank you.
you reminding us. All right, ladies,
Yes, and welcome on board, Allison.
Thank you. I appreciate it.
Yes.
I'm glad to be here.
absolutely. No other items on the agenda. It's a late hour. Do I have a motion for adjournment?
So moved.
Second. All those in favor, please signify.
Yes.
Aye.
Have a good night.
This was a long one tonight.
Good night, everybody.
Good
Be
night.
safe.
Thank you.
Be safe.
Thank you. Everybody be careful.
So far, next week, so.
Good night, guys.